Can you beat a lie detector test? How accurate are they really? And if they are accurate, why don't we use them in courts across the country? And if they're not, then why does every law enforcement agency in this country use them for investigative purposes? Good evening and welcome to HCCLA's Reasonable Doubt. My name's Carmen Rowe and I'm the president of HCCLA, the Harris County Criminal Lawyers Association. We're the largest local criminal defense bar in the country. And tonight we're going to be talking about polygraphs, how they're used, when they're used, and why they're used, with our special guest, polygraph examiner John Schwartz, as well as local criminal defense attorney and Professor David Cunningham, with our host, Jimmy Ardwan and Damon Parrish.
Thank you, Carmen. Good evening, everybody. Welcome to another edition of Reasonable Doubt, sponsored by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, along with my co-host, Damon Parrish. We thank you for joining us for what's sure to be another great episode. As always, please send us your questions on Twitter for our guests tonight. We'll take them live on the air. It's at HCCLA_TV. You can also call in starting at 8:30 with your questions for our guests, John Swartz and David Cunningham. It's going to be a great show. We're going to talk about, as Carmen said, polygraphs, their admissibility, and how they're being used by defense lawyers, how they're being used by law enforcement, and what the practical uses are in the defense of many cases around the country. But right now, I want to bring in my co-host, Damon Parrish. Damon, good evening. How are you?
All right, yourself, how are you doing?
I'm doing well. I want to start off by talking about the big case that made headlines this week here in Houston, and that is the charges that were filed against a Bay Area man with regard to shooting a dog in a dog park. And as I understand it, I've got the charge right here in front of me, and it's out of the 177th District Court. The charge is actually cruelty to a non-livestock animal. It's a pretty extensive probable cause affidavit. Kind of tell us a little bit about what you understand the facts to be.
Well, so on January 25th, Joseph Potts, I believe his name is, was with his dog at a dog park. Says his dog was being attacked by this other dog named Diesel. So out of self-defense for himself and his dog, he shot Diesel 3 times. First shot, I believe, was around the head, body area. The dog went down but didn't die. And then shot the dog 2 more times and killed the dog. The Diesel's owner, from the moment it happened, protested the shooting of his dog, said his dog was not attacking Joseph Potts or his dog, and that this was just an unjustified, cruel killing of his dog.
And now, Potts is a CHL owner, so that may add an interesting defense wrinkle into the case. And like I said, it's extensive probable cause affidavit I'm looking at, and somewhat unique in that it has multiple dates of interviews with witnesses and everything else. And right now, the case is just a charge. So this is one that's likely to be a fight at the grand jury as well, don't you think?
I do. And I think the fact that he's a CHL owner is a double-edged sword. He couldn't have the gun on his person in the park if he wasn't a CHL, concealed handgun license carrier. At the same time, he's charged at a higher standard. You know, if you have a CHL, you're asked to be in more control of your weapon, in more control of your emotions, and to use better judgment. And so it's if he didn't have the CHL, maybe he wouldn't have the charge, maybe he'd have a different charge, who knows?
Well, it's certainly an interesting case that I think we need to keep a watch on, because our district attorney, Devin Anderson, has come out herself and spoken about how aggressively she wants to prosecute animal cruelty cases. And so I think this may be kind of a test case to see where this is heading for her administration. Next issue I want to move to, or next item I want to move to, Damon, is our I don't know, our former Secretary of State, Hillary Clinton, and the email controversy. We talked a little bit last week about David Petraeus and the charges against him, but it seems like we may have another Washington political figure getting charged, or at least talk of it, in the sense that Hillary Clinton may have used her personal emails in the course of her job as Secretary of State. Tell us about that.
Well, first thing, we can say that it wasn't May. She definitely did. So there's no issue if whether or not she did or didn't use her personal email account. The question is that allowed and is that proper for the Secretary of State to use a non-government email account? And the last question is, did she use her personal email account to send top secret and secure emails, which themselves should have been done on a government account? I guess the last question also would be the retention policy, because as you're aware, those emails are supposed to be saved for Kingdom Come, and apparently she also mass deleted a bunch of emails. So we know it's politics season, we know it's presidential season when we start seeing news about politicians that are like, it's delete mail gate. You know, that's what
she may have gone to the Lewis Lerner School of Email Retention.
Right.
I guess we'll see what the Department of Justice does with that. I understand there's an investigation that's ongoing. I'm sure we won't get much out of Mrs. Clinton at this point, but it's certainly to be a hot button issue if she does declare her candidacy for the presidential nomination.
This will just be a thorn in her side. I don't see any criminal prosecution coming from this. I really don't. This is just, it's time for a new president, so therefore it's time for dirt, and who knows, whenever the front runner for the Republican Party shows up, we'll learn about something silly about this person that might require a criminal investigation, but in and of itself, it's just move on.
That's probably true. Final item before we get to our guest this evening. We need to talk about what happened in Ferguson last night and what happened a couple days ago. We had the police chief resign. We had some other members of the local government there resign, and it culminated in riots last night.
Again, so last week we talked about how the DOJ released a report about Ferguson.
Right.
And in that report, one thing was clear: they were not going to press charges against the officer involved in the shooting. Another thing was also made clear: the Ferguson Police Department is rampant with, I won't say rampant, but had high issues of racial misconduct and sexual misconduct, in that they targeted blacks, they targeted minorities, and that they were not investigating sexual harassment claims and allowed sexual harassment to take place in the workplace. One thing we've learned subsequently is that the police force basically act as a tax collector for Ferguson, and their goal was to collect revenue for the city through fines and whatever have you. From that report, there's been a threat by the federal government that, hey, we might just dismantle your police department. We might just get rid of all you guys and start anew. So first thing you do, just like in NCAA rules, you self-impose sanctions. Ferguson has done that. They've self-imposed their own sanctions. The police chief has resigned. A top clerk who was responsible for some of the emails, those racially charged emails, quit. He was fired. Another person was fired, and then another officer quit or resigned ahead of any kind of scapegoat, whatever. So what we're seeing is Ferguson PD and Ferguson themselves are trying to clean house, and the community, one, is saying, hey, we asked for this a long time ago, and two, this isn't enough.
I understand that. It may not be the best response, unfortunately, but needless to say, I don't think this is going away anytime soon.
No.
So I think we're gonna be dealing with Ferguson and the fallout from the DOJ report and the fallout from these resignations for quite a while. I think it's something we need to keep an eye on here, and I'm sure you'll continue to do your due diligence and research and keep us informed of everything, just like you do every week on the current events.
It. I want to say something quick about the rioting. Riots are not the best response, but they get attention. And when the people themselves have no other revenue, another outcome, or no other way of showing their disdain with the government, when it results to rioting, usually something positive can come from that. And so it's my hope that they stop rioting. It's my hope that they continue to go through the proper channels, but I understand where they're coming from.
Well, sometimes you have to hit rock bottom in order to
climb out.
Get back up.
Right.
I want to turn to our guest now, John Swartz, a very experienced former federal polygrapher, and as Carmen said, the professor and experienced criminal defense attorney David Cunningham. Guys, thanks for joining us this evening. We really appreciate it.
Our pleasure. Thank you.
John, I want to start with you because you're the man with the equipment in front of you, and that's the main reason why we're here. You brought the toys with you this evening for us to play with. Give us a little history about the polygraph, the use of polygraphs, and just in and of itself, how it came into being. And
certainly. Well, first of all, polygraph examinations have been experimented with since approximately World War I. There were a number of early persons who were looking at this sort of thing, and by the end of World War II, the Central Intelligence Agency in Washington set up a polygraph section to test all applicants looking for spies, to detect people that were involved with espionage and things of that nature.
And as I understand, it was the former head of the CIA who actually set forth kind of the standards that we use today. Is that correct?
The first chief examiner's name was Cleve Baxter, who he just passed away about a year ago. But he set the standards that we use worldwide today, and he developed testing formats that are still in use today, and they work very, very well. But what happened is it's expanded to law enforcement agencies and intelligence agencies around the world. We're not the only country that uses polygraph. Colombia, South Africa, even the Russians use it today to vet their applicants and things of that nature. And today it's used more widely in criminal cases here than anything else.
Now most people will probably know it as it's commonly referred to, the lie detector test.
Correct.
Is that really an appropriate name to call it?
It works, but today it's polygraph testing, and they moved beyond that to call it psychophysiological detection of deception.
And so what exactly are you testing for?
Okay, what we're measuring are called sympathetic nervous system responses during questioning. There's a branch of your brain that's called the autonomic nervous system. And within that autonomic nervous system, there are two branches, and they are the sympathetic and the other branch. There are two branches, and the primary branch is the dominant side. And in an emergency situation where you have what's called the fight or flight reflex, it takes over. And so this is the same thing, or the same phenomenon that would happen if you were involved in a near accident and suddenly you get out of the way of the 18-wheeler and you can feel your heart beating heavily. This is what we're measuring on a test. So when the body detects a threat, whether it's audible, verbal, whatever, or a visual threat, or if someone were to walk in here just now and fire off a round from a gun, we would all respond instantly, and that's what we're seeing on the test.
Now, the test is made up of questions. It's made up of a series of questions. We've all seen it in the movies and on TV. Usually somebody's hooked up to some contraption where they've got things wrapped around their head or on their fingers, and there's somebody on the other side of a table with asking them questions, and they've got a little thing that goes up and down, and that's kind of the image we have. We've got what you use right here in front of you, but talk a little bit about the questions, how the questions are structured, and what you as the examiner are trying to do with your questions.
Okay, first of all, let's talk about the instrumentation.
Yes.
What you used to see on television are what are called analog instruments, and that's the big Halliburton case where the papers are running on top and the pens are running. We've gotten away from that in the last 20 years to computerization. Today, this little box here digitizes the signal, and physiologically we have 4 attachments that go on the body. These are called pneumograph tubes. Okay, and one goes around the stomach and one goes around the chest. It measures breathing on the test. And the reason we have 2 is because you have different nerves that innervate your chest muscles versus your stomach muscles.
And by the way, there are a number of people who would like to see you hook David up to this machine tonight.
Absolutely.
I'm sure David's ready. All right.
A number of tough questions.
These little plates here measure what's called electrodermal response. And at the microamp level, when we ask the questions, if there's a sympathetic nervous system response, I see an upward deflection of the pen. Lastly, we have a blood pressure cuff that measures blood and pulse pressure during the questioning. So we're looking at four parameters at the same time. To get to your question about the questions themselves, we have testing formats that have been developed over the years, and it's just like they've been validated through hundreds of thousands of examinations. It's just like if you went to MD Anderson and you had a problem with a cancer issue, they would say, we're going to give you this particular combination of drugs because it's been validated and we know that this works really, really well. So there are some significant testing formats that we use, and that allows me to use a quality control. So if I run a test, for example, on David, and I need a second opinion, I can send those charts to another examiner and say, this was a testing format that we used. This is what I asked on the test. Would you please critique this?
And so what types of sources of information do you use in order to make your questions?
Well, normally if someone's been charged with a crime, it would be the offense report or the charging document from the court, so we know exactly what the allegations are. So we don't go on a fishing expedition. We narrow the questions only to the scope of what the state is alleging.
What happens in a situation where there's not a charging instrument yet, but you know there's an investigation? What types of things would you want as an examiner to look at or to know? I mean, is it something that you would want to talk to a witness? Is it something that you would want the defense attorney to give you a synopsis? In that scenario, how would you construct the questions?
I would want a synopsis, but there are times when it's better to wait and say, let's hold off. There's no rush on this. Let's get more information so we know what we're shooting for, because we don't go on fishing expeditions.
So John, when you're administering the test, how do you tell a difference between a nervous answer, which may be truthful, and an untruthful answer, which still may be nervous?
And during the interview or during the test?
During the test. So if I'm in this chair and you ask me my name, I'm not nervous about that, because telling you my name won't involve any kind of criminal charges. But once you get to the meat of why I'm here to either prove I'm guilty or not guilty, correct? So when you start asking questions about this charge, I might be nervous because I want to make sure you know I'm not guilty. How does a machine know, or can a machine tell a nervous answer from a untruthful answer?
That goes into the question formulation on the examination, okay? This goes back to what Jimmy just asked me. We have a combination of questions in the format. We have what are called irrelevant questions, sacrifice relevant, control questions, which are also known as comparison questions, and the relevant questions. The relevant questions are, did you do it? Did you light the fire? I mean, what we're measuring on the test is always an overt act. Did you light the fire? Did you steal the TV camera? Did you shoot Bobby last Wednesday night at the bar? But we have other questions in the deck, the control questions, and where the relevant questions are a possible lie answer because you don't know if he did it or not. The comparison/control questions are designed to give the innocent person something to respond to if they didn't do it.
Okay.
And for example, let's say we have a theft from the Frost Bank and someone embezzled $100,000. The relevant question would be phrased, did you steal any part of that $100,000? And the reason it's phrased that way is because it might be an employee conspiracy. Perhaps I stole the $50,000 and my partner who acted as a lookout got the other $50,000. Okay, so this way you don't allow that person to rationalize out of the issue. But the control questions would probably be phrased before this year, did you ever steal anything from someone who loved or trusted you? Did you ever cheat anyone out of anything? Did you ever steal anything from a place where you lived? Where the relevant questions are possible lie answers, the control questions are probable lie answers because we've probably all done something like that. So if the person really stole the money, he's waiting for that relevant question. But by contrast, you want to give the innocent person something to respond to and say, you know, I didn't steal the money, but, you know, I stole money from my mother when I was a small child or whatever. And it goes down to what we call the concept of psychological set or saliency. And that is the person being tested is going to psychologically focus on the question or questions that pose the greatest threat at that moment in time. And control question testing is the most validated form of polygraph testing in the world today.
Okay, so basically you compare the nervous answer, be it truthful or be it a lie, versus another answer given and see where the difference lies. You see where a truthful answer has been given and a potential lie has been given and see which spectrum is closer to. Is that how it works?
More or less. I mean, what we're looking for is where are the greater responses. If the greater responses are in the control questions, you've got a truthful person. If the greater responses are in the relevance, he's lying to you.
Okay.
David, I want to bring you in because you've had a lot of experience in the defensive cases where polygraphs have been used, and I'm sure you've had to deal with this quite a bit in your practice. From the standpoint of the admissibility of these exams in court, where do the courts stand on it?
Well, it's interesting that John talked about these tests starting right after World War I, because you start to see the first challenge to the admissibility of polygraph tests in the 20s. And polygraph evidence was the genesis of what we call the Fry Rule, which dealt with the admissibility of scientific evidence. And that was the rule for the admissibility of scientific evidence for almost 70 years until Daubert in the 1990s. So when you track the history of the admissibility of polygraph evidence, it's pretty interesting, and it's fairly consistent. Generally speaking, courts under the Fry test found basically 3 reasons to exclude the evidence. Number one, it was unreliable. When you read the old decisions talking about why it was unreliable, they talk about irregularities in heart and respiratory things. They talk about problems with the qualifications of the polygraph examiners and things like that. Many issues, I think, probably have been addressed in the interim. But they claimed that the test itself was unreliable. The courts also said that these tests, the admissibility of this test, would invade what we call the province of the jury. Since time immemorial, we've looked to jurors to use their common sense, to look at a witness's his bias, his demeanor, the plausibility of the story in determining whether or not that individual is truthful. So the theory is that this testing would invade the province of the jury. And again, still leading up to the changes in the law in 1993, the courts then said, this is going to cause a confusion of the issues. If you're going to admit polygraph evidence, there's a real possibility you're going to have a battle of the experts. One side brings in their polygraph examiner, the other side brings in their polygraph examiner, and you get away from the issues. There was some thought in the 70s that some trends were starting that would allow the evidence to be admissible, but that never really came to fruition. In the 90s, the test for the admissibility of scientific evidence changed. We have the Daubert test, without boring people with the requirements, but it's generally considered a more permissive test. And people thought, wow, maybe this is the way that we can start to get polygraph evidence into court. Again, those hopes didn't come to fruition. Polygraph evidence is generally inadmissible. Well, let's back up. It used to be there would be a per se rule against the admissibility of the evidence, okay? Mm-hmm. Courts have largely thrown that out the window. They'll say, we'll consider the admissibility of polygraph evidence if it meets the 5 factors in Daubert. So, when you look at the case law, it's still, for example, in Texas, inadmissible. Largely inadmissible in the Fifth Circuit, which is the federal courts that we all practice in.
Right.
And the reasons, again, deal with what they call the inherent unreliability of the process, the possibility that you're going to invade the province of the juror. We've always relied on the jury to make the credibility determinations, and the confusion of the issues. So that's the reasons that the courts look, generally speaking, to exclude that evidence.
Now, as a practitioner, though, you can still use these to your benefit in, for instance, an investigation to find out if your client's telling you the truth. So you have some issue to work with there. Also, as part of your investigation, if you're doing a grand jury investigation,
right.
The polygraph is still admissible in the grand jury. Correct?
Absolutely, and I've used it in a lot in these 2 circumstances. One is the grand jury presentation, where you get a eminently qualified polygrapher like John to do the examination and present the results showing no deception to a grand jury as part of a packet, and I've had success doing that. But here's another avenue for using the polygraph, and it's used in sex offender cases, and I used John to do this. I represented an individual, a young individual that was charged with possession of child pornography. And of course, as soon as you hear possession of child pornography, I don't care who you are, most people are going to be worried, is this person acting out on the urges? And one of the things that I wanted to do to try to shift the playing field at an early stage was to do a life history polygraph to show that this individual may have looked at the images but had never acted out on the images. And once we did that, the prosecutor's perception of the case changed, because we got the notion that this defendant was a fixated pedophile put to bed early. No pun intended.
Yeah. Well, and I want to, since you brought up the sex offender issue and how it's used in those cases, John, I want to bring you back in, because one of the ways that it's being used now, it's being used to test probationers and parolees in sex offender cases, isn't it?
That is correct.
And tell us how it's being used.
Well, it began about 20 years ago, and in 1995, here in Texas, we had a group of senior polygraph examiners got together with a bunch of senior sex offender counselors, and they formed a committee in Austin called the Joint Polygraph Committee on Offender Testing, also known as JEPCOT. It's known as the JEPCOT guidelines. But they established guidelines to test these people at various stages of their therapy while they were on probation. The first test is the instant offense test, and that is, did you do it? I mean, a lot of times we have sex offenders, pedophiles in denial. They'll blame the 5-year-old victim and say, she came on to me, or you know that all. Anyway, they would use this as a tool to identify whether or not they committed the offense. And the position of most of the therapist is, if the person really didn't do this but got pushed into taking a plea on something that didn't happen, then we don't need to be treating these people, because there's so many people who really do need the treatment. Once we got past that, and I mean, the majority of the therapists, it's like AA, you've got to admit you've got a problem, like I'm an alcoholic, I'm a pedophile or whatever, before you can get the treatment from the therapy program. So once...
Sure. No, I was going to ask, so who administers these tests? Is it when they're on probation, is it the state of Texas, or the examiners employed by the state of Texas, or do they come to somebody like you?
Initially, the therapists were coming to the private examiners like me. And what happened is one of the courts here took immediate notice of a special test that had been run where the man made some tremendous admissions, and that particular court said, we want you to test everybody from now on. At that point, all the other courts began doing it as well in Harris County, and thus sex offender testing began here. At that point, they normally do what's called a sexual history examination, which comes about a year later. These people on, say, 5 or 10 years deferred adjudication. About a year after the instant offense, they do the history, which gives them time to put together everything they've ever done sexually. And that would include all prior victims, all prior offenses, all prior deviant acts. It can be a fairly long and inclusive test. I've had some that go as long as 6 and 7 hours, just going through all the admissions. Once that's on the table, if you've cleared all that stuff out and they pass on that issue, then after that, there's nothing left to test on annually, but usually a monitoring test, which is, have you committed a new offense? A maintenance test usually has to do with any other probation violations like alcohol, traveling out of state without permission, or whatever else is of concern to the probation officer. The vast majority of those that we do here are monitoring tests to make sure they're not reoffending.
David?
Actually, David, I had a question for you. So after hearing what John just said about the testing, do you, in your opinion, as a defense attorney, do you think the testing is used more, the sexual history testing is used more to help in counseling or to find new offenses? A 6-hour review on everything you've ever done sexually in the past, is that done to help or to hurt?
That's a tough one to call, because I don't know the rationale that the community supervision would use for that. My guess is, not my guess, but they say that they have to have this sort of testing to know whether the person is compliant. And being truthful, because it's just like AA, you've got to admit you have a problem before you can go forward with the rehabilitation and treatment. So,
from the defense lawyer standpoint, though, obviously this is a big concern when you advise a client to take a deferred adjudication, and now you've got this wrinkle of a lie detector test as a condition of probation. how do you advise the client? What do you need to advise the client of? And what are some of the pitfalls, and what rights did the client have to reject taking the lie detector test?
It's interesting because when you asked me to come on this show, I hit the books and did a little reading, and we all know that, like John just talked about, it's very, very common for them to do, after you're on probation, to do the life sexual history examination. Interestingly, the Court of Criminal Appeals recently, in December, held that you don't have to answer those questions. You can invoke your Fifth Amendment privilege to those questions. And you can do that in the context of a polygraph examination, and you can do it in the context of counseling. When they ask you to go back in and talk about your prior situations, have you been with, sexually victimized other people? You have a Fifth Amendment right to not answer those questions. And the court says you can't use the invocation of that right alone to revoke someone's probation.
That's a huge issue.
Yeah, exactly.
Yeah.
So,
and
it's interesting because in that case, the defendant failed a number. Actually, he refused. He was doing well in his treatment, progressing according to plan, but he just refused to take the polygraphs. And the probation department and everyone says, the prosecution says, if you take the polygraph, we'll withdraw the motion to revoke. He said, no, I'm not going to do it. The court revoked it. The Court of Criminal Appeals ultimately said you can't do that because he had an absolute right to invoke his Fifth, and you cannot penalize him for the invocation of a constitutional right.
Great decision. We've reached 8:30, so I want to remind our viewers we've opened up the phone lines. We'll put the phone line down at the bottom of the screen. It's there right now, 713-807-1794. Also, we've got the Twitter up and running, so please send us your questions at HCCLA_TV. John, I want to come back to you for a little bit because we talked about, when David was talking about the Fry and the Daubert cases, he was talking about some of the problems that the courts have found historically. And one of the things that you and I have talked about with regard to the frailties of any of these exams is the examiner themselves. And I think David had brought that up, that the court's concern was that the examiners haven't been qualified enough. What type of qualifications do you have to go through to become a certified polygraph examiner?
Well, it varies from state to state. In Texas, you have to have 5 years of criminal investigative experience, and not as a street patrolman, but as a criminally investigative detective where you're working criminal cases, and or a 4-year college degree. At that point, you have to attend an APA certified school, of which there are, 14 or 15 in the United States. And when you complete the training from an APA certified school, at that point you have to find an intern sponsor, and that runs approximately a year. In Texas, the trick is finding a sponsor because a lot of people aren't willing to sponsor an intern. It's time consuming and lots of paperwork and things of that nature. I've done one in my career, and it's a lot of work, but that's what it takes to get on board. So Texas probably has stronger guidelines than most states in terms of qualifying examiners, but that's what you have to do.
Now, I know oftentimes law enforcement, and we'll delve into law enforcement and their polygraph, the extent to which it's being used, but we know that HPD and several other agencies, they have examiners on their staff, and they like to request that people under investigation come and submit for polygraphs at HPD or at some other law enforcement agency. You found in your practice that there have been frailties in the past and with the certification and some of the ways in which the examiners within the police departments and law enforcement have run their examination units, correct?
That is true.
And if you can, elaborate on that a little bit. What kind of issues have you found?
Mostly it was technical issues relating to the administration of the examination itself. I can think of one case where a police officer, a senior supervisor, was polygraphed by his own department over an allegation. And when I was asked to quality control the charts, I found the examiner had failed to ask a relevant question, and they still tried to score the charts and call it deceptive, and you cannot do that. That just invalidated the entire examination, and he was fired from his job. He ended up going before an arbitrator, and I was called in to be a witness to testify as to the accuracy of the test, and the only thing I could tell the arbitrator was, it's no good.
So not accurate.
Yeah.
Totally inaccurate.
David, what are some of the things? I mean, could there ever be a day, given the current state of law in Texas, when we could see polygraphs become admissible? And what do you think it might take in order to get to that point?
You know, I was thinking about that today. If it's ever going to happen, why do they keep it out? I read that you know, the accuracy ratings, the accuracy of a polygraph is 70 to 90%. I think it's going to be a long time before it even is considered admissible. It's what I call the yellow legal pad theory. I mean, for so many years, the courts have considered jurors to be the exclusive judges of the credibility of the witness. Judges are not going to want to prolong trials with battles of experts, one side of another. They think that the use of a polygraph examiner coming in and giving that sort of testimony is going to put the focus on the expert rather than the witness. I think it's going to be a long time before it comes in, just because, you know, we've always used yellow legal pads. I don't know why they're yellow. They've always kept out polygraph evidence largely. I think that's going to continue for a good while.
So John, I had a question for you. So you were talking about, and it's about Jimmy's question. And so with the police sergeant, I want you to assume for the moment that you and I are both competent polygraph examiners. We are both respected in our fields, and so I am John 2. You're John 1, I'm John 2. Can we both look at the exact same polygraph and see different results? Meaning I look at it, if for some reason I see deception, but you look at it and you see truthfulness. How subjective are the reading of polygraph results to the individual polygrapher?
We score them numerically, okay? They're on a number line, so we give a numerical value. If the greater value is in the control question, we'll give it a plus mark. If it's in the relevant, we give it a minus, and it's over a certain threshold, it's a deceptive test. Now, ideally, because we're all trained to do the same thing, I should be able to give you my charts and say, what do you think? And you should come up with the same score that I have. If we've got a difference of opinion, then we've got a problem. And that's when we call in a third party and say, time for you to score these charts as well and tell me what you think.
Okay, so it's you who score the charts. It's not like your laptop and your machine, although it's digital, doesn't say that question's a 6, okay, that one's a 4, okay, that one's a 3. You look at it and you use your experience to say this number is this number is that. Is that how it works?
We have two ways of doing it. There's numerical scoring. That's the manual method that we've used for years and years, and that's the standard by which everything else is judged. Within the computer, we have an algorithm that scores it as well, and it's nice to have a second opinion to see what the computer thinks. Normally, they should concur with one another,
right.
But that's it. Okay. And bottom line is, if I've got a tight test and I don't know exactly what I've got, I can come to you and say, hey, tell me what you think. And on occasion, I do that. And every good examiner should have a quality control.
So the tests aren't necessarily pass-fail. They could be pass-fail and it's undeterminate?
Inconclusive.
Inconclusive?
Inconclusive. Okay. If you get an inconclusive test, it's because you have an inconsistent set of responses, okay? One chart may look deceptive, the next one's non-deceptive, the third one is, what do I have? It doesn't happen very often, maybe 1 or 2 in 100, but if you've got something like that, there's usually a good reason for it. And I can think of a sex offender that I tested some years ago, and it was a true inconclusive. His offense was against his granddaughter, and it was an annual monitoring test to make sure he'd committed no new offenses. What happened is he was inconclusive, and at that point, you turn everything off and say, what is going on in your life that you didn't tell me about before? And it turned out his son was going on trial the next day for armed robbery in one of the district courts. It was going to be his 3rd felony conviction, and habitual violator. He said, look, I can't think of anything else but that issue. So you turn everything off and say, go home and get past the trial or whatever else personal issue that he's got. Come back in a month or 2, get past that issue, and we'll test you. And I've never seen a time the second time around where we couldn't conclusively test them. That's how it's done.
Good.
I'm curious because the machine, the instrument, and the test in general has been used to clear a lot of people, a lot of defendants, pretrial. Could be used in an employment situation to clear somebody. But talking in the criminal defense world, for focusing on that for the portion of this question, oftentimes we use it to help our clients either in the grand jury or even in investigation stage. And David, I know you've been there. A lot of times the prosecutors will say, we'll have your guy go submit to a polygraph and we'll consider it. Why is it not what's good for the goose is good for the gander? How come they don't require an investigator or a DA require the same thing of their complaining witness?
Boy, I wish I had the answer to that. I think that's something that should be done more often. We all know of that rare occasion where a prosecutor will have their witness or their complainant take a polygraph examination. It's very, very rare. You've seen it in some cases where maybe a prosecutor is concerned that years after the fact someone may be actually innocent and want to put the complaining witness subject them to a polygraph examination. I agree with you. I think it should be done more often.
And John, I think you had an experience with that some years ago where you actually were part of testing a former complaining witness in a case, some 15 years after the fact. Isn't that right?
We've had several like that. The one that comes to mind more clearly is a San Antonio police officer who was charged with rape. And this was a woman he was dating, and she charged him with sexual assault. He was arrested, held in the jail for 6 months in Bexar County. And I was called by the chief prosecutor at Bexar County DA's office, who said, "This offense report just stinks. It just doesn't look good at all. Would you please test the complaining witness?" I tested her, and the relevant question was, before you went out with him that night, did you make any plan to report this to Internal Affairs? She failed the test miserably and immediately admitted she made the whole thing up.
Nice.
How many of those have you actually done where you've tested the complaining witness over your career?
A lot. Now, no, we don't do as many anymore. There was in Texas years ago, it was fairly routine to test female complainants on rape cases, and the women's rights groups just went against that, so it's not done very often at all.
And I want to talk about the countermeasures. We had discussed. There's all of these sites out there.
A lot of myths about how to be a
how to beat a lie detector test. I mean, there's some people out there that they bill themselves as trying to teach people how to defeat lie detector tests. Can you really beat a lie detector or the polygraph?
Not really. I mean, you can try, but it doesn't diminish your ability to respond to the relevant questions. Now, there are certain things people can try, like enhanced breathing and certain covert movements. Good examiners see that in a heartbeat, and we've got one example I think we brought in here tonight of someone who tried to do that, and that would be right there on the screen.
Yeah.
If you'll notice in the green zone, before we get to the green zone, you'll see the top two tracings are inspiration and expiration. That's the pneumograph tracings. And you'll notice just before we enter the green zone, I separate those tracings with a click of the pen. But you'll notice as soon as I ask the question, this particular person takes a long, deep breath, and this is deliberate and intentional. This is a countermeasure. And this went on, this person had been coached, but not well. And what happened is she failed the test. She was in jail for capital murder and doing a life sentence. And we were asked by one of the media organizations to test her to see if, in fact, she had committed the offense. She did everything she could do to beat the test and still failed.
So, along the same questioning, what about, I've also heard, and I'm going to throw out some myths I've heard. You tell me if you think they're valid or not. One, using a thumbtack in your shoe. So that right before a question that you know is a baseline question, or a question that it's okay to lie to, you step on it, it increases your heartbeat somehow, and then it makes your entire chart high, or something to that effect. And then 2, taking a drink of alcohol or something before the test so that you're artificially more relaxed, more down.
That does not diminish your ability to respond to the relevant questions. Okay, if you have a thumbtack in your shoe, there have been times we've been forced to have the person take their boots off and put them in the corner or whatever, but it really doesn't affect their ability.
So you've seen that before?
It's happened.
I've heard of it, but I didn't think it was real.
We actually have a pad that the person sits on to detect covert movements because we've developed other things. We've identified other things that people try to do covertly in terms of movements, and the pad identifies that, and we see that as a 5th tracing on the screen.
Oh. We got our first call tonight, so I want to get to our phone lines. Hello, welcome to HCCLA Reasonable Doubt.
Hi, you've answered a number of the questions that I initially wanted to ask, but what type, the lie detector test, okay, or in law enforcement, how are they used internally, and are they really accepted throughout governmental agencies and so forth? So that's my question.
We had a little hard time hearing you there. You're breaking up quite a bit. It sounded like he was asking whether or not, how frequently they're used within governmental agencies.
At the federal level, every federal law enforcement agency in the United States has a polygraph section. IRS, CIA, FBI, DEA, you pick it. They've got a number of examiners and quality control sections as well.
John, David, I want to flip to you on that because you have a very heavy federal practice. How much more do you see the polygraph used on the federal side versus the state side? Is there any difference that you see in terms of the frequency or the quality?
In the investigative portion of a case, I see it much, much more often on the state side. It's because in the state side, you can have a chance with a well-designed, well-prepared grand jury packet with a polygraph showing no deception. You have a chance to get a no bill there. That's unheard of, at least to me, in the federal side. So I see it more often in the investigative side from a defense standpoint in state court. Looking back over the years, I've seen some polygraph examinations done in the federal cases, but it's been relatively rare for me.
Yeah.
David, I had a question for you as well. When it comes to the defense side, when it comes to a polygraph examination, have you ever had to get one to refute the state's polygraph? I know they're coming to court, but let's say you had a situation where a prosecutor was just gung-ho and for some they have a polygraph that shows deception by your client. Have you ever had to get your own to refute that or enter into a battle of experts pre-trial?
No, I haven't come across that.
John, I want to go back to the government portion of this and I want to focus now on what they do with inside their hiring practices, because I think this is a big portion where polygraphs are used today within the federal government, and that is the hiring of agents, the hiring of other employees within the FBI, the CIA. Tell us a little bit about what you know with regard to that testing that's done.
Well, a good example is the Central Intelligence Agency. They've been using it as long as I can remember, before I was born. There are 2 tests they administer pre-employment to employees. One is a lifestyle test and one is counterintelligence. The counterintelligence test is, have you ever been in contact with an agent of a foreign government? Another question is, do you have a mission? And that's the hottest question in the deck because every spy has a mission. Things of that nature.
Employed, right? That's kind of a open-ended question, right? What's a mission and how does it work?
Well, it depends on what happens, honestly. I don't think they get that many people that have that problem with that question, but it's one of the things that they look for. The lifestyle thing has to do with drug usage in the last 3 years. CIA is pretty straightforward. Have you used any illegal drugs in the last 3 years, period? And that's it. So if you're 35, they really don't care what you did when you were 15 years old. There's a question about committing major crimes. There's a question about hacking into government computers, because that's a big deal today with the Chinese, the Iranians, and those people. So that's what happens there. In the law enforcement agencies, there's usually a question about drug usage, Have you fully disclosed all prior instances of drug usage? And at one point, they would never hire you if you'd used drugs even at all. Over the years, that's changed because society has changed. And I think today, as long as you admit that you haven't used marijuana more than 15 times, you're employable, but you've got to clear that question.
How often are they used, for instance, in an internal affairs investigation or some sort of disciplinary action if they believe there's misconduct on the part of an agent or an officer?
Federally, in the federal agencies, if the Office of Professional Responsibility is called in, and that's a fancy name for internal affairs, they'll conduct the entire investigation. And if there's any final questions, at the very end, they can offer you an examination, but you have the right to refuse it.
Now, David, I've subpoenaed a few employment files in my day on officers, and I've never seen a polygraph test that's been turned over to me. Is that something that you think defense lawyers should get a little more specific in their requests?
It sounds like a great idea to me. If it's a common practice, you might as well throw it out there. You just might hit the mother load and get a polygraph exam results.
Are more and more agencies going to these things pre-employment, during employment? Where's the frequency of the exam being used with law enforcement in terms of their internal questioning of their employees?
Well, since 9/11, virtually all the federal agencies in law enforcement, if you're hiring someone for a special agent position or a core series position, you're going to take a polygraph test. The one who requires it periodically after that is CIA. If you come back from an overseas position, if you've been assigned to, say, South Africa or Libya or wherever, if you're back in the United States, you'll take a periodic after that. I'm not aware of any other agency that requires anything past that. The agency that's actively testing everybody today by congressional mandate is Customs and Border Protection.
And as I understand it, the CBP, or Customs and Border Patrol, they're something like 7,000 candidates behind in terms of their testing.
I've heard that.
I mean, that just seems like an insane number right now.
There's a lot of applicants, but it's a big agency.
I think it's under the Homeland Security Agency, Department of Homeland Security now. They've all been fed into the same department. Is it unique to each agency, John, or is it would HHS be the one to oversee the polygraph exams?
They've all got their individual quality control sections and their own management, issues. I don't know that much about the other agencies other than to say I know they're all testing, and they all have their own individual leadership that develops the standards that they have to go by.
John and David, I have a question for both of you guys. Both as a lawyer and as a practitioner, have you ever seen a polygraph exam used, and have you done one in a non-criminal setting? So let's say in a divorce case to prove a cheating spouse or not, or in a contract case to prove whatever you need to prove. I mean, do you focus only on the criminal aspect, or have you ever seen, either of you, this being used in the civil side as well?
As I was getting ready for the show and reading up on some case law, I came across a Fifth Circuit bench trial where the court ruled the polygraph exam was admissible, and it had to do with an insurance claim.
Okay.
So yes, I've seen it happen, but I think it's pretty rare.
Do you think the level of the standard for admissibility, Daubert, I know it's criminal, is the same thing applied in civil side as well, or is it a lower standard?
Well,
you have a standard.
Well, in this case, it was a little bit unique because I really think that the test came in because one of the lawyers kind of fouled up and opened up the door for the admissibility of the test.
So, John, have you ever had to do a polygraph or a non-criminal or non-investigative hiring situation, say for a civil suit, divorce?
Certainly. We do those a lot. I don't do infidelity tests at all, but we've had certain issues, especially in family court, custody battles. Invariably, one parent says that the other parent inappropriately touched the child, and they bring it up as an issue. So that's happened, and I've had to testify in a few trials like that.
All right. So you said you don't handle infidelity. So if we narrow down to family law, do other examiners handle infidelity, or is there a particular reason why you don't handle infidelity?
Well, I think they're a lot of trouble, quite frankly, because it's a no-win scenario. I've done some in the past, and most often they don't show up for the test at all. If they do, no one's satisfied. It's just not worth it.
So it's not a problem with the test, it's just more trouble than it's worth as far as administering the test and getting the results.
That is correct.
All right.
David, why don't more lawyers use polygraphs in the investigative stage of their cases?
I think financial reasons. It's not that an examination is it's not very expensive. Even if you're using a very qualified examiner like John, it's not terribly expensive,
Right.
to me. But when clients that are low income, scraping by, trying to get together a retainer, sometimes it's just money that they don't have.
It can make a huge difference, though.
Oh, absolutely, absolutely. I'm begging a client now to try to come up with the money.
And on, for instance, if you're court appointed on a case, would applying for funds, would this fall under something that a lawyer could fall under to get funds for an expert to have something like this?
Well, that's a good question. I don't know if sometimes the judges are a little tight with the purse strings. If they have difficulty parsing out $750 for an investigator, they're certainly going to have trouble parsing out $750 for a single test polygraph exam, single answer polygraph exam. So I think most judges would have a problem with that.
And along those same lines, David, we know that's not admissible in trial, but can you still introduce a polygraph result, say, for mitigation? So you have a client, sexual assault, and you want to show that, hey, he looked at pictures, but he actually didn't, at least as we can tell, never touched anybody. Didn't come in at trial, but can he come in for punishment as far as mitigating to help lessen that impact?
I don't think it would come in front of a jury. I could see that you could include it in a packet to a court and get it in your memorandum to the court and hope they consider it.
So I guess my next question is, I understand it's not admissible, but let's say I agree to it and you as a prosecutor agree as well. So we both are in agreement, we're okay if you bring this in front of the jury. Can it come in then, or is it still a Darber analysis?
In Texas says even if you stipulate to it and both parties agree, it's not per se inadmissible, but it's inadmissible.
We've only got 30 seconds or so left on the program, guys, so I want to thank you both for coming and joining us tonight. David, I thank you for taking the time to prepare and reading case law and doing all the heavy lifting to give our audience all the information they need on this. I really appreciate it.
Heavy lifting.
Yeah.
John brought the instruments.
Thank you for inviting me.
Absolutely. We appreciate you guys coming out, and thank
My
you
pleasure.
for your insight on this. Thank you for joining us, everybody. We look forward to seeing you again next week. For my co-host, Damon Parrish, good night.